Hi there. Continuing with a day in the life of a small business employment attorney series. And this one is kind of a misnomer because I'm going to be talking about wage and hour law today, but specifically in the context of in-home care. So as you know, we have an aging population and there's plaintiffs attorneys out there that are making buku bucks. It's a racket out there on what I'll call as caregiver wage and hour law. The reason I said it's a misnomer is because if you've hired an in-home caregiver to care for your aging mother or father or whatever family member, and that caregiver is hired essentially by you, even though you're not a small business, believe it or not, you're an employer under California law and need to do all the things from a payroll perspective and a wage and hour perspective that a small business employer or any business, quite frankly, in California would have to do. And we'll talk about that, of course, before we get off this video. So first, what happened today? Today, I just got off the call literally with someone who cold called my firm, actually emailed my firm, and they have a father with dementia, and they had someone who they say worked only a few hours a day here and there, basically to do heavy lifting things like bathe her father. She says she was there quite often. She lived down the street, and basically had hired this person to come in during the day, paying them $150 a day, which you're going to find out is a big mistake. A day rate, we call it. You definitely don't want to do that. You want to pay by the hour. Basically hire them as $150 a day, and they performed according to this potential client about an hour here and there, hour here, hour and a half there, hour in the evening to bathe the father. All right. Of course, as is often the case, they had a parting of the ways, which was not amicable. And next thing you know, this potential client, and by the way, this is just an individual, right? Could be you, could be me. Think about your situation. If you've got aging family members, what's the caregiver situation for them? It can be anyone. And this goes for, anywhere in the sunny state of California. One individual could be an employer of become an employer simply of this caregiver. And another term for it is personal attendant, somebody who just provides companionship to somebody who's elderly or disabled and provides basically basic personal hygiene type things, helping feed them, helping give them a bath, personal hygiene type activities, personal attendant or in-home caregiver. Now this caregiver, even though they only worked a few hours a day, actually lived in the home of the father, rent-free in one of the bedrooms. So this person had their own bedroom, stayed there 7 days a week, lived there basically, rent-free. And so you're thinking, wow, this, individual potential client is a good person, right? I mean, you're letting them live there rent-free, paying them $150 a day for maybe 4 hours of work, doing the rough math, that's close to 40 bucks an hour, right? When the obligation is only to pay California minimum wage, or if there's a local minimum wage in your city or county, then that local minimum wage. But as of right now, 2025, August, almost September, California minimum wage is $16 an hour. So we use that as an hourly rate for our example. So how could it be this is all messed up? And it really is. So this person who hired this caregiver to care for the father did not do basic wage and hour things that an employer should to avoid wage and hour claims. Number one, they did not have this employee keep track of their hours worked, i.e. a time record, right? So they're telling me they worked an hour, say from 8 to 9, feeding the father breakfast, and then from 1 to 2, spending some time with the father-in-law, feeding them lunch, watching some TV. And then, another hour and a half at night bathing the father. 3 to 4 hours a day is what they're telling me. But I don't have a time record to prove that. So that's mistake number one. Mistake number two, this $150 a day business, they pay cash or by Zelle. And like I told this individual, luckily we paid some by Zelle because at least we have proof of payment. Because believe it or not, folks claim that they work for you. And by the way, this person did caregiving duties for about 1.5 years off and on. They claim, after the fact that they worked for 1.5 years and never got paid a dime. Sounds ridiculous, but sorry, we live in the sunny state of California, live and work there. And this is the kind of crazy stuff that happens. Now, it's not a credible claim, really, but they do make them. But what is the problem? The problem is I don't have time records, or this potential client doesn't. And most folks wouldn't think to do this, but I'm telling you all there, if you've hired a caregiver, make sure to keep an accurate record of every single second they work, at least on a handwritten time sheet of some kind. Because right now I have no record or really good firm evidence to rebut this person saying they worked there 24 hours. And by the way, and this is a critical point, if the caregiver works alone, lives in 24/7, 7 days a week, 24 hours a day, lives alone with the person they're giving care to, then believe it or not, under California law, all it takes is for the worker to be under the control of the employer, right? And the employer actually can be the demented father, but the daughter is acting as with power of attorney to hire the worker, right? But if they have to stay there overnight alone with a demented elderly person, one could easily argue that they could not leave the premises. They actually had to be there to watch over the elderly demented client 7 days a week, 24 hours a day. And that is an argument, believe me, plaintiffs' lawyers who focus on this area, caregiver, wage and hour law, contend. And it's a viable argument. And when you run those kind of numbers, let me get out my calculator. The law is you have to pay a caregiver first 9 hours is regular time. So let's say $16 an hour minimum wage. So whatever that comes out to be, that comes out to be. But then anything over 9 hours up to 24 hours in the work day, like a 24-hour day, so the other 15 hours can potentially be overtime. Luckily, it's just overtime and not double time, which is the normal overtime rules under California law. Anything over 12 hours in a workday is double time. But fortunately, there's a carve-out that says for personal attendant caregiver that anything over 9 hours in the workday or over 45 hours in the work week is just overtime. I say just, but here's the numbers, right? If it's $16 an hour times 15 hours times 1.5 because of the overtime, that's $360 a day that my potential client, for example, did not pay this person. They paid $150 flat, but that only covers, under California law, the first 8 hours work, in theory, right? Even though they only work 3 to 4, they got even a better rate of pay based on the day rate. But that day rate does not cover the 15 hours of overtime. So you're looking at potentially $360 a day when you think you're paying this caregiver $150, $360 more that you potentially owe them in overtime. Times 7 days a week is $2,520, $2,520 per week, times 52, and that's $131,000 plus a year. Shocking numbers. So hopefully I have all of your attention. If any of you are thinking of hiring a caregiver and they're live-in, worst case scenario, live-in, and they're the only ones living in with the person they're giving care for, this is the kind of crazy numbers we can get to. And these are realistic. Now, fortunately, in my case, potential client, the demented father is married, has a wife still, and the wife is just fine, lives there on the property as well. So we have the demented father, we have the wife living on the property in the residence, and we have this caregiver living in a room on the premises rent-free. So what I told her was, not good we don't have time records. You need to have time records going forward if you do this again. Not good we paid cash. Not good that we didn't issue actual paycheck, withhold taxes, employer taxes, pay employer taxes, all that good stuff. Not good. But at least we have a key witness, i.e. the mom, who can testify that she was there 24/7. Also watching over her husband, giving care to the husband, just not doing the heavy lifting things. And maybe this caregiver did come in just 3 or 4 hours a day here and there. Even though they lived on the property, they only worked 3 or 4 hours a day. But in order to win this case, if it ends up coming my firm's way, we have to be prepared for the caregiver to get on the witness stand and lie and say that they had to stay on the premises 24/7. We're going to have to put on our witnesses, the mother, the wife, who says, no, that's not true. I was there 24/7. I also fed my husband. I also changed his clothes. I also did all these other things. I also was his companion and stayed with him. You could have gone and left anytime you wanted to. You just got free rent. And then we have the daughter come in who says she was often there a lot during the day. She lived down the street. Her brother was there a lot. So we put on witnesses, right? But why is that still a problem? The problem is, let's just do things the right way so we don't get sued. Because like I tell all my small business owners, and in this case, not a small business owner, but a householder, right? A daughter, once you've been sued, you've already lost. And believe me, this person is totally shocked by what I've been telling her. Spent a lot of time with her on a free consult because she's just flabbergasted that she could possibly be in this crazy situation, right? I estimated her potential damages based on the rate of pay that she paid this person. If they were to prevail on a 24/7 theory, it's like $250,000. So, and rightfully so, she's absolutely shocked. But that's the potential reality, right? I mean, and if she gets sued, guess what? She gets to pay my firm, right, or some law firm to defend her. I mean, I haven't told her this yet, but she could probably defend herself because she's an individual. Not that she would want to do that. Probably want to hire a lawyer when you've got $250,000 at stake. And I told her, look, you've lost because you've got to hire us, right, a law firm to represent you. If the other side gets anything on these wage and hour claims, they're going to get their attorney's fees automatically. So even if they get 10 or 15,000, the attorney's fees bill could be another 150, 250,000 or whatever, depending on how hard the case is litigated. If these numbers are shocking to you, they are, but this is the reality, in California when it comes down to wage and hour claims. So, like I said, spent a lot of time trying to answer her questions. She's trying to understand the process. And, ultimately, here's what I told her, right? I mean, right now, she doesn't even have a demand letter. She just received a records request, and there's no records to provide because she doesn't have any. And so I basically told her, just ignore it at this point. Don't do anything. Oh, but the demand letter says if I don't respond by such and such date, they're going to file a lawsuit. I have to tell her, but that's what every records request says, right? And, every demand letter that follows says. And so I told her, look, what's 95% probability of occurring next is you'll get a demand letter from this law firm, not just a straight up lawsuit. They'll probably send you a letter first. 5% probability, maybe they just go straight to a lawsuit. But whether, they file a lawsuit or not, or just send a demand letter, you're going to want to settle the case. Well, I don't want to pay this guy anything. I don't owe him anything. And this is where my job gets difficult because people just don't understand what my daily life is like, which is like dealing with these lawsuits all day long. And even if the lawsuit is utterly bogus, once you've been sued, you've already lost. The plaintiff's lawyers have all the leverage. The plaintiffs have all the leverage, and they know it. And so even if there's no merit, zero merit to the case, they can bring a lawsuit, file one. They know they'll get their attorney's fees if they win. So it's a lot of pressure on small business owners, or in this case, a homeowner, a daughter, to settle totally bogus cases. So I told her, look, 5 or 10,000 minimum just to make it go away is going to be well worth it. Because the alternative is you end up paying my firm way more than that, probably in the first couple of months, if we have to come in and just defend the case. So whether you settle now at the records request stage, after you get a demand letter, or even after you get sued, our job for you is going to be to settle the case, to make it go away so that you don't end up paying more money overall. I mean, more money what you pay us and what you end up paying them. because they're just not going to go away for free. Ultimately, you're going to have to pay them something to settle the case so that this former caregiver gets paid and their lawyers get paid something. And believe it or not, 5 or 10K to make this go away would be well worth it for this person, even if we feel like there's no merit to the claims. So, hopefully there's some lessons that have been learned here. They're applicable to any small business. Keep track of time, cut a payroll check, don't pay cash. I mean, I can't tell you how many times small business owners come to us and they've paid cash, even if they've kept track of time. And a lot of times they don't even keep track of time still, and they pay cash. Very bad. So that's a day in the life of a small business attorney for today. Well, hi there, Scott Shibayama here. This is an addendum to the video you just watched. And it's time for me to eat a lot of crow because when I recorded these videos, or the video in 2025, I made reference to the California statewide minimum wage being $16 an hour. That's wrong. It was and is, as of January 1, 2025, $16.50 an hour, $16.50. So to the extent I made any reference to the California state minimum wage on this video at $16 an hour, you need to replace that number with $16.50 an hour. And any mathematical calculations that I use based on the minimum wage, for example, the salary basis test for exempt status being a requirement of a salary that's the equivalent of at least twice the California minimum wage. Instead of 16 times 2, you need to use 1650 times 2. So $33 times 2080 in a standard California work year. And whatever that number comes out to be, that's the minimum salary to satisfy the salary basis test under California law. And while I'm on the topic, I didn't mention this, and I'm sure all of you employers to whom this applies already know, but for certain healthcare employers and certain restaurant employers, namely fast food employers, larger ones, the minimum wage is much higher than $16.50. And of course, there may be a city or county minimum wage that you need to be cognizant of as well. So once again, my apologies for the error on the video. It's $16.50 California minimum wage in 2025, not $16. Aloha.